criminal law and procedure. Vicarious liability, liability for the actions of another based on the relationship between the parties. Accessory, one who knows that a crime will be, is being, or has been committed and assists the principal. Unlike an accomplice, an accessory is generally not at the crime scene. Accomplice, one who aids, abets, or facilitates the commission of a crime and has the intent to assist the primary party and the intent that the crime be committed. Liable for all crimes and foreseeable crimes committed. May be convicted even if principal is acquitted. Solicitation, when one entices, encourages, or requests another to do an unlawful act with the specific intent for the crime to be committed. Merges with the completed crime, and generally there are no defenses. Attempt, slap, a substantial act towards completion of a crime, specific intent and apparent ability beyond mere preparation towards actual perpetration of committing the intended crime. Merges with the completed crime. Conspiracy, agreement between two or more persons with specific intent to commit an unlawful act or a lawful act by unlawful means, and an overt act in furthering the objective. Does not merge with the completed crime. Homicide, the killing of one human being by another human being. Actual cause, but for the defendant's acts the result would not have occurred. Proximate cause, it is foreseeable that the defendant's acts would have created the result. Murder, unlawful homicide with malice aforethought. Malice may be demonstrated by intent to kill, intent to cause serious bodily harm, reckless and wanton disregard for the high risk to human life, depraved heart, the felony murder rule, whereby an unintentional death occurs during the commission of an inherently dangerous felony. First-degree murder, murder committed with specific intent to kill, deliberation, and premeditation. Second-degree murder, murder which is not murder in the first degree, can be an unintentional killing. Voluntary manslaughter, intended unlawful homicide without malice aforethought and adequate provocation. Mitigation, note, any and all defenses need to be looked at for mitigation. Heat of passion, killing must have followed provocation before the defendant had the opportunity to cool off. Provocation, a reasonable person would have been provoked and the defendant must have been provoked. Cool off, a reasonable person would not have been able to cool off and the defendant must not have cooled off. Involuntary manslaughter, unintended killing without malice aforethought, accidental homicide. Misdemeanor manslaughter, a killing without malice committed during an unlawful act not amounting to a felony. Kidnapping, intentional moving, confining, or restraining of a person without privilege or consent. Burglary, breaking and entering into the dwelling house of another in the nighttime with the specific intent to commit a felony therein. Modernly, trespassatory entry into any structure with intent to commit any crime. Larceny, the trespassatory taking and carrying away of the personal property of another with the specific intent to permanently deprive, as opposed to embezzlement, a low-level employee. By trick, obtaining possession of the personal property of another by trick or deception. False pretenses, obtaining title to personal property of another through a known false statement of material fact with intent to defraud. Embezzlement, fraudulent conversion of rightfully entrusted personal property, as opposed to larceny, a manager. Robbery, trespassatory taking and carrying away of the personal property of another with the specific intent to permanently deprive, in their presence and with the use of force or threat of imminent bodily harm. Receiving stolen property, acquiring or controlling property known to have been stolen with the intent to permanently deprive. Impossibility, legal versus factual. Legal impossibility is a defense when the defendant's actions would not have been a crime. Factual impossibility is not a defense when the defendant's actions would have constituted a crime. Insanity, MIMDI, M-I-M-D-I. M'Naughton rule. Defendant does not know the nature or quality of their act or does not know that the act was wrong. Legal and moral aspects. That's for the MBE. Irresistible impulse. Defendant lacks the ability to control their conduct. Model Penal Code, Mpc. Due to mental disease or defect in reasoning, the defendant lacks substantial capacity to conform their conduct to the law or appreciate the wrongfulness of their conduct. Diminished capacity. An impaired mental condition short of insanity which is caused by intoxication, trauma, or disease, and which prevents a person from having the mental state necessary to be held liable for a crime. Infancy. Due to age, incapacity to commit a crime, 0 to 6, rebuttable presumption, 7 to 14, juvenile/adult, over 14, children participating in adult activities may be held to an adult standard. Intoxication. Involuntary. An affirmative defense to any criminal or negligence charge, not just specific intent. Voluntary. Used to negate specific intent. Consent. Because consent was given freely, there is no crime. Defense of self. Reasonable force necessary to protect oneself up to and including the use of deadly force. Defense of others. Reasonable force necessary to protect others with whom the defendant has a special relationship up to and including the use of deadly force. Defense of property. Reasonable non-deadly force necessary to protect one's chattel. Necessity. A person is privileged to enter the land or interfere with the chattels of another if it is necessary to protect a person from death or serious bodily harm. Protection of more than 2 others is an absolute defense. Less makes a defendant liable for damages. Lawful arrest. Requires probable cause which arises from trustworthy facts or knowledge such that a reasonable person would believe the person committed the crime. Valid search warrant, affidavit, must be filed in good faith based on reliable information showing probable cause, issued by a neutral magistrate, and specifically state the place to be searched and the items to be seized. Search and seizure by a government agent. Examination of a person's body, property, or other area where a person has a reasonable expectation of privacy. Taking possession of a person or property. Invalid search and seizure. Evidence and derivative evidence obtained in violation of the 4th, 5th, or 6th Amendment is generally excluded as fruit of the poisonous tree. Exceptions include a reasonable good faith reliance on an invalid warrant, independent source, and inevitable discovery doctrines, which may allow evidence to be used. Warrant exceptions. Consent. One with actual or apparent authority voluntarily consents, officers may search. Consent may be revoked at any time. When revoked, search must stop immediately. Plain view. An officer who is lawfully present in an area may seize an item if it is imminently apparent that the item is contraband or evidence of a crime. Exigent circumstances. Emergency situations or where evidence is about to be removed or destroyed. Search incident to lawful arrest, SILA. An officer may conduct a search of the arrestee and his wingspan during a lawful arrest. Special rules apply to arrests that occur in vehicles. Automobile, vehicle. With probable cause to believe a vehicle contains evidence, contraband, instrumentalities, or fruits of a crime, an officer may conduct a search. Administrative. Border searches do not require a warrant if routine, reasonable, and conducted pursuant to established agency policies. Stop and frisk, Terry. Stop. Officer needs reasonable suspicion that a crime will be, is being, or has been committed. Can only stop the person briefly. Frisk. Officer needs a reasonable belief that the suspect is armed and dangerous, and the officer may only frisk for weapons. Miranda rights. Attached during any custodial interrogation. Custody. A reasonable person in the suspect's circumstances would not feel free to leave. Interrogation. Questioning initiated by law enforcement or its functional equivalent. Invoking rights. Clear, unambiguous, unequivocal invocation of the right to remain silent and the right to speak with an attorney. Waiver. Must be made voluntarily, knowingly, and intelligently. Violation of rights. While physical evidence may be admitted against a suspect, no verbal communications made after the invocation of the right to remain silent may be used against the suspect. Sixth Amendment right to counsel. An effective assistance of counsel, offense specific. Attaches in criminal cases once formal adversarial judicial proceedings have commenced. To demonstrate ineffective counsel, defendant must show that the counsel's performance was deficient and the result of the trial would have been different. Waiver must be made voluntarily, knowingly, and intelligently.